It's Tuesday, it's February 18th. We are back in court in Massachusetts. Why? Well, Karen Reed is back in court today. Last week, we read through the motions that were filed. This week, we are hearing the attorneys argue in court regarding those motions. So the attorneys are going to be talking about the metadata, I am sure. We are going to hear some of the initial motions, but what they are not going to address today is what many of you are waiting for. And that is the motion to dismiss. That's not being argued today. It hasn't been turned in yet. The defense has a few more days. That is due February 21st, and that's not going to be argued until the beginning of March. So for everyone that's going to ask, why hasn't this just been dismissed yet? I understand. That is not the question before the court today.
So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
Pissed.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
She's pissed. Well, today was unexpected. When we got through some of the motions, the court called a timeout on the hearing today and continued it to next week. So we are not through everything because the court said, nope, we're stopping right here and we are going to resume 11 a.m. Eastern, February 25th, 2025. Why? Well, as they were arguing over the ARCA experts, remember we referred to them on the channel as the crash daddies. They made a cannon to shoot glasses into a Lexus taillight to see if that replicated the smash pattern. They talked about whether or not John O'Keefe was hit by a vehicle, whether or not they could reconstruct the accident. They were the experts who testified in the federal grand jury proceedings, who were hired and retained by the FBI and the U.S. Attorney's Office. Remember, when that went to trial, Lally, at that point for the Commonwealth, argued that they had no discovery regarding these witnesses, and there was a court order that said the parties weren't allowed to talk to the witnesses. Then we had a colloquy that was read back in court today by Special Prosecutor Brennan that said, so defense, you're telling me, and I am summarizing, this is not verbatim, you're telling me that you are bringing in witnesses that you have not spoken with. And the defense said, yes. We have the discovery turned over by the feds. They had the federal grand jury transcript so they could see their prior testimony. So it isn't like they didn't know anything. And they had not prepped them. And the court said the solution to that was a voir dire. And then there was a full day where the court allowed for the ARCA experts to be questioned outside the presence of the jury before they testified before the jury. The Commonwealth made a motion to exclude the ARCA experts based on discovery, saying that the defense did not turn over all of the reciprocal discovery regarding those experts to the Commonwealth, and said that if the defense can't turn over the necessary expert discovery, then these experts can't testify. And that's where we picked up today on that motion. Brennan saying, look, I'm not saying that the ARCA experts shouldn't testify. I'm saying they can't testify without reciprocal discovery, and the discovery we've been turned over so far is troubling. And then Brennan got into a number of emails that he said initially were turned over by the feds, and then corrected himself and said they were turned over by the defense. Those emails seem to indicate that there was ongoing communication between the ARCA experts and the defense after the voir dire and before the testimony. There was also an email where the defense seems to have offered to hire the ARCA experts, and the Fed said, please cease that line of communication. It also seems that there was an invoice from the ARCA experts to the defense for somewhere around $23,000. The chat asked whether that could be for travel expenses. It doesn't really matter what the expenses are for. If the defense paid ARCA anything and that was not disclosed, that should have been disclosed during trial. It was after that recitation of information from the Commonwealth that the court took almost a 30-minute break, came back out and said that she was deeply concerned and that this information might have large ramifications or repercussions for the defense and the defense attorneys, and then stopped the hearing for today, saying that when we resume on the 25th, everyone can be prepared. There was much frustration over the court ceasing the hearing today. But it is my perspective, and I know many of you won't agree, and that's fair. It is my perspective that this was the proper thing for the court to do if the court thinks that this is a big deal. To give the defense time to prepare their response to this and to more fully vet the timeline. I suspect that the court will go back and look at what the orders were with regard to when you can talk to the ARCA experts. It seems that some of those communications were in between the voir dire and the testimony. So if it's just a discovery violation, that's going to be different than if it's a violation of the court order, which is going to be different. When was this discovered? When was it turned over? When did these communications happen? All of that is going to matter to determine how big of a deal this is. There have been a lot of discovery violations in this case, a lot of them from the Commonwealth. So if it's a discovery violation, it's different. If it's a violation of a direct court order, that can be different. But I'm sure the court is going to want to go look exactly at the language of the court order regarding conversation with those experts and look at what the defense said on the record. So I imagine the court's going to go back to the transcripts and even ask Brennan, what about the transcripts? If that was made more of in court by Brennan, the court's not going to be happy about that either. So I think we will see the court taking a beat to allow the defense time to prepare and respond. It sucks for Alessi, who came down from New York to argue his motions today, and we didn't even get to them. But the court was like, this is a problem, and we need to take a look. Whether it's a violation of a court order, whether it's a violation of discovery, we will see. But I think the court pausing to give the defense time and to take a step back and be prepared for this is appropriate to do. Frustrating, yes. Appropriate, also, yes. It might be made more of by Brennan. It might be a bigger deal. But the defense would not be the only party in this case that has had discovery violations. But if the defense represented to the court that they had no preparation with these witnesses, these emails seem to indicate that there was some communication and prep with these witnesses in between the voir dire and the testimony. So when did the defense make that representation? Before voir dire? Or did they represent it again after voir dire? And the court and the Commonwealth and the defense, and I'm sure the internet, are all going to go look at those things. Other things that happened in court today are completely overshadowed by the dramatic ending of the hearing midway through. We didn't get to all of the pending motions. We didn't even get to the motion that I was really interested in, which was the defense motion from Alessi to exclude the Commonwealth expert. I really wanted to hear what was going to happen because it seemed like the court ruling on that one was pretty clear that the non-doctor witness can't give medical opinion. I wanted to know where we were going with that, but no, cut off, absolutely. So this may or may not be a big deal. I am sure in the next week, there is going to be much speculation over it. I am going to wait to see what papers are filed in court. I may also go back with y'all on stream to take a look at what was said on those days, and I've linked them down below because we have those days. But there's also going to be things that happen at sidebar that we don't know that will probably come into these motions. If there are more filings between now and the next court date, I will go over them. So we will see if this is a big something or if this is something that was made to look like a big something and really isn't as big as it seems. But yes, there have been discovery violations on both sides, it seems. And yes, there is still a motion to dismiss that the defense is filing on the 21st. And yes, this case is going to continue to heat up ahead of the retrial on April 1st. And surprisingly, we've got Karen Reed giving an interview to the media. I have not had a chance to watch it yet. I've been sick. It seems that a juror has come forward. Jurors have given statements to the press. There's a lot more information about this case outside of court that might impact how this case goes forward in a month and a half. This is not going to slow down. So the other motions in court, the court ruled on a very few of them that were no objection. And then there was quite a lot of objection, non-objection, but non-objection. Brennan saying, Your Honor, I'm not objecting, but you need to know about whether or not the defense would get to bring in another attorney. And we heard argument about that in court today too. Will the defense be allowed to bring in another attorney pro hoc vice, which means in this case only, who also represents Aidan Kearney, who is known around the internet as Turtle Boy, who has been covering this case. And there are separate litigations going on to the side of this case there. And the Commonwealth made a lot of notes to the court. Your Honor, it's not an objection, but you should be aware. And so that pro hoc vice is going to also be litigated. We'll see if it gets litigated on the 25th, but we're going to have to take a look at that. And that's over whether or not Attorney Betterow will be able to join the defense team. And I imagine the Commonwealth will also bring up statements, if statements have been made that attorney made outside of court. Again, that attorney was not part of the case with regard to Karen Reed before this, so they're allowed to give comment on the case. But we'll see what the Commonwealth has to say as notes to the court that aren't objections, but kind of are. But again, if you're not the attorney on the case, you can give comment on a case. So when you become an attorney on the case, then there are different rules that apply. Today was a lot. It was not the longest hearing that we've seen on this case, but it was a spicy one for sure. All right, law nerds, we'll be back in court on this case on the 25th, but I will be covering any filings between now and there because there's going to be some fallout on stream. So get the Law Nerd app so that you know when we're starting. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.